us now. Mr. Asaduddin Owaisi has joined the opposition rank to question the government over its demonetization policy in the wake of the Supreme Court judgment. Despite, you have the Supreme Court upholding it, Mr. Owaisi has asked that who will take responsibility of over 100 deaths that happened due to that bad policy decision, according to him. Let's listen in to Mr. Owaisi, then I'll cut across to my colleague Swastika.
अकाउंटेबिलिटी से बच नहीं सकते आप सरकार। भाई इसका पॉलिटिकल, इकोनॉमिकल, सोशल, मॉरल रिस्पांसिबिलिटी तो देश के प्रधानमंत्री पे आयद होती है। इस मुल्क की गरीब आवाम रो रही थी, वजीर आजम, प्रधानमंत्री हंस रहे थे। 99.30% डिमोनेटाइज मनी अब सिस्टम में आ गया, तो इसका मतलब कोई ब्लैक मनी रिकवरी नहीं हुआ। जीडीपी ग्रोथ गिरा नहीं गिरा, डिमोनेटाइजेशन गलत फैसले की वजह से प्रधानमंत्री के। इंडिया का जीडीपी ग्रोथ 2016-17 में 8.3% था, उसके बाद क्या हुआ, 2019-20 में 4% पे आ गया।
Cutting across to my colleague Swastika, who continues to be with us on the broadcast. Swastika, still many people from the opposition, including the Congress and the likes of Mr. Owaisi, continue to say that there were innumerable sufferings that happened due to demonetization, and the country won't forget that. So the final word on this issue has not been said. The Supreme Court and its judgment does not put a pause to the political discourse around it.
No, it certainly doesn't, and the outcome is what Mr. Asaduddin Owaisi had also raised. In fact, he says that demonetization, upholding the minority judgment in this case, he says that demonetization failed to achieve the purpose with which it was brought in. He says this was bad in law. It was an erratic decision that was made by Prime Minister Modi without even taking the RBI into consideration. He also said that demonetization resulted in loss of life to the tune of 100. He says nearly 50 lakh people, quoting a study done by Azim Prem University, saying that nearly 50 lakh jobs were completely taken away by demonetization. And he ultimately questioned what was the purpose of this exercise where the majority of the poor in this country face the brunt, so much so that they are still continuing to reel under its impact. These are the questions that were raised by Mr. Asaduddin Owaisi, and he also, in fact, took a final dig at the Modi government, saying if BJP indeed thinks that demonetization was a successful exercise, then why are they not celebrating Notbandi Divas, or why are they not celebrating demonetization as they do in case of other events?
Swastika Das getting us all the details as far as the political discourse around it is concerned, the latest one being Mr. Owaisi joining that entire bandwagon. But let's tell you what the court said. What is it that the Supreme Court 4 judges said when they upheld the constitutional validity of the exercise of demonetization? The purpose of demonetization was proper. There was prior consultation that was held. So one has to understand that when the matter went to the Supreme Court, we are largely debating that whether a proper procedure was followed or not. It's not relevant whether the objective was achieved or not. The objective, its achievement, whether the objective is right or wrong, it's the domain of the executive or the elected government of the day. It's not for the Supreme Court to decide. There's a nexus between clamping down on black money and demonetization. One of the key tests that any court of law looks at is that there was an objective you wanted to achieve and there is an action you did. Is there a link between the two? The court said, yes, there is a link. Action and time period given for currency exchange not hit. So different factors that were taken into account. Were the people given enough time? Was there enough room for grievance redressal and other things? Government has power to demonetize all series of banknotes. A particular section of a particular act was cited to say that all kind of notes cannot be demonetized. The power with the government is limited. The court said no. Object was noble. Process undertaken was bad in law. This is the sole dissenting judge, and that is what she has said. Justice B.V. Nagaratna, who at some point will be the Chief Justice of India, the first woman Chief Justice, she has said that policy should originate from RBI, Central Board, and not government. Her argument is that these are decisions which are best left to the expert bodies and should not be taken by the politicians solely. That's her argument. There was no independent application of mind by the Reserve Bank of India, and any kind of consultation that was done by the RBI was only an afterthought. That's what Justice B.V. Nagaratna has said. Entire exercise was carried out in 24 hours between November 7 and 8. The government said, we did this to maintain secrecy. The government, the dissenting judge on the bench says the government should have done some more consultation. Opinion of RBI Central Board was sought after demonetization decision. So as I said earlier, any kind of consultation that was done was an afterthought. It was not done before the exercise was really carried out. I want to cut across to my colleague Ananya Bhatnagar, who's been tracking all the developments at the Supreme Court of India. Ananya, let's break it down for our viewers. What the Supreme Court has decided today is that the procedure that was followed by the government was right. And under the relevant actions, under the relevant sections, the actions of the government were proper in law. A particular act was cited, a particular section was cited to say that this is a power with the central government which is limited. And all kinds of currency notes cannot be demonetized. Let's talk a bit about that.
Well, Anusha, this is Section 26, Part 2 of the RBI Act, which is about whether any series of a particular currency note or all of it could be, in fact, be demonetized. This was the question before the Supreme Court was. While the 4 judges upheld that the centre has this power to, and this any can be read as all, the dissenting judge, Justice B.V. Nagaratna, says that it could be dangerous if this power actually is given out and all of the currency notes or all of the series could be given out. If at all the central government wants to do it, is what Justice B.V. Nagaratna says. If a particular note like the 500 rupee note, all series has to be demonetized, then the government should do it by way of a legislation. While the 4 judges on the bench have also said that the policy was correctly in fact rendered, it was correctly executed, the dissenting judge, Justice B.V. Nagaratna, had to say that though the intent of the policy was right, though the intent which it was brought in to tackle counterfeiting, to tackle fake currency, to tackle the black money aspect as well, and the terror financing, it was correct. But then when it comes to the legality of this particular policy, it was wrong, because it is the RBI who can actually initiate the step of demonetization, and if at all the centre wants to do it, it is only by way of legislation it can do it.
All right.
If at all it wanted to
Ananya,
do it,
I'll come back to you, and we'll talk
of
about the dissenting judgment a little bit more. Whether a proper legislative route should have been taken, should the government have opted for ordinance, because Justice B.V. Nagaratna has spoken about that. Before that, let's also listen in to what Union Minister Prahlad Patel said.
उच्चतम न्यायालय के निर्णय का मैं अभिनंदन करता हूं और एक विनम्रतापूर्वक आग्रह भी करता हूं। नोटबंदी का अभियान सिर्फ नोट बदलने का अभियान नहीं था। आतंकवाद में उपयोग होने वाला काला धन, वो लोग जिनको चिन्हित करना जरूरी था। मुझे लगता है सरकार ने जो अपना पक्ष रखा उसमें बड़ा स्पष्ट कहा है कि सरकार ये मानती है कि निश्चित रूप से कुछ लोगों को कठिनाइयां भी हुई हैं। सफलता के साथ में जो कष्ट हुआ है उसको सरकार ने स्वीकार किया है, लेकिन हम उसके भीतर जाकर झांकने की कोशिश करें।
Cutting across back to my colleague Ananya Bhatnagar, who continues to be with us on the broadcast. Ananya, who were the key petitioners? These were a batch of petitions before the Supreme Court of India. Who were the key petitioners? There's also an argument that the opposition is raising, not trying to get into the politics of it, but the legal merits of it, that what was challenged before the court was not the merit of the policy, but whether a proper procedure was followed in implementing the demonetization exercise. And as you were talking about Justice Nagaratna, she also essentially spoke about how proper procedure needed to be followed when they implemented the demonetization exercise. Ananya.
Well, definitely, Anusha. 58 petitions were filed before the topmost court of the country challenging this particular policy of the central government. And Mr. Shyam Devan and Mr. P. Chidambaram, the former finance minister of the country and also senior advocate, had argued on the point of the petitioners. They had put forth the petitioners' voice, and they had said majorly 4 key points. Number 1, that in fact the procedure with which the demonetization policy was brought is deeply flawed. Secondly, that the central government withheld crucial documents, including the letter that was sent by the central government to the RBI informing about this policy. In fact, it also withheld the document with regards to the quorum that had met during the RBI central board meet and how this whole decision was taken. So this was the charge that was given out by the petitioner. In fact, it was also said that the policy does not go by the test of proportionality. However, the central government had countered all of these arguments, saying that the policy number